Okay, so hey everyone, my name is William. I'm currently a senior at Ladue Horton Watkins High School, and this is my guide on topicality, which is one of the fundamental negative arguments when it comes to policy debate. So I've titled this Topicality an Intro to the Rules of the Game because my approach to topicality sort of gets into the idea of debate as a game, and we'll talk about that more and look at how we can debate topicality, what topicality is, and we'll get into the caveats of analyzing resolutions and doing all that fun stuff that we do in topicality. So to start off, I just want to introduce this idea that debate is a game. So what exactly makes something a game? Well, first of all, a game has win conditions, and debate certainly has win conditions. When you're up against your opponents and you're debating them, ultimately the win condition is the judge signing off for your team on the ballot. And within the actual debate itself, we can do this in a number of ways. These are all different ways that we can win a debate round. We can talk about the disadvantage and compare it to the case. We can talk about a counterplan and a disadvantage and compare that to the affirmative case. We can have case turns. We can talk about inherency and solvency. All of these things are things that you should be familiar with when it comes to how we win policy debate. The other thing that games usually have is a set of rules, and policy certainly has a set of rules. We have a set order of speeches. We always have set speech times, prep times, and cross-ex times. Evidence disclosure, sometimes there's rules, sometimes there isn't. Typically there is evidence disclosure. And then finally, there's the idea of what arguments each side can run. Now, the reason I have this last one in bold here is specifically because what arguments each side can run isn't really written in some official rule book. In fact, policy debate and its rule book is actually fairly limited because a lot of the primary rules or limits on what types of arguments that we can actually run are actually done through the process of debating itself. So this is sort of getting into the idea of theory, where it's like we say this type of argument should be able to be run and this type of argument shouldn't be able to be run. And one of the best ways to introduce this type of abstract rule setting or this a way to introduce this type of abstract concept is through topicality. One thing I'd like to note is that most of the time only flow judges and only some flow judges will actually know what you're talking about if you go into a round and you try and make analysis about debate as a game. Most of the time, lay judges, they won't really see it that way. They'll just see it as like an argument, and then they'll pick whoever they think won the argument, and they won't try and frame it as like a game with a bunch of rules or a bunch of win conditions. So that's important to keep in mind, especially throughout this entire lecture, because topicality is one of those nuanced arguments that I personally feel is a bit difficult to run in front of a lay judge, but later on we can talk about how to run topicality effectively in front of a lay judge as well. So let's get into topicality itself. So topicality is, at its core, an argument that is very similar to a disadvantage, but there's a couple of specific caveats about topicality as it relates to how debate works. So the structure of a topicality is 4 parts. First is the interpretation. So if we don't already know already, which we should know, there's a resolution which tells us what types of plans that the affirmative team is able to run and has to defend in the debate. That resolution obviously has a bunch of words in it, and topicality comes down to the idea of whether or not the plan that the affirmative team is running really falls under this resolution. So the way we make a topicality argument is through this basic structure. So we have an interpretation, which is a definition of a word or phrase in the resolution. Then we have a violation, which is basically how the affirmative plan or the affirmative team doesn't fall under that interpretation of the word in the resolution. Then we have standards, which are reasons for why the violation or why the affirmative team not meeting your definition is bad. This case usually for debate, and then we have impacts or voters, which are reasons why a judge should care about the violation or why the affirmative team isn't under the resolution. So I want to go a bit more in depth into standards and impacts, which are the final 2 parts of a topicality argument. So you can think of this sort of like a disadvantage in that there is links and internal links and impacts. In this case, our link would be sort of the violation. We say the affirmative plan doesn't meet the resolution, and that would be our link. Then we'd have an internal link, which basically says the violation that the affirmative team has made is bad, and that leads to a number of bad impacts. These are typically in topicality debate known as standards. So we have limits, ground, precision, framers' intent, bright line, and predictability. There's definitely more than these 6 standards, but these are definitely the most common standards, at least in terms of what I've seen. So going into what each of these 6 standards are, first we have the idea of limits. So limits basically says, you can think of it as like, if you have if the entire literature base for a topic, so for example, this year's criminal justice reform, if the entire literature base for a topic is everything that exists on the internet, limits is the idea that the affirmative basically only gets, limits is basically the idea that the affirmative can only specifically pick certain number of affirmatives. There are limits on what specifically they can run in a debate round. The second thing is ground, and the ground is basically this idea that the negative has arguments that they must be able to run, and the affirmative has arguments that they must be able to run. So in the case of this year's resolution, which is criminal justice reform, one might argue that specific negative ground would be maybe the idea of deterrence, right? The idea that punishing criminals deters crime, and therefore reversing, like making progressive criminal justice reform is bad for deterrence and bad for crime rates. So that would be an example of an argument that the negative might say is core neg ground. So the standard of ground would basically say that because the affirmative doesn't meet our definition, they're basically taking away ground from the negative. They have arguments that they should always be able to run that suddenly they're unable to run. The next is precision. So precision is this idea that the definition that you provided is important in some way in the real world for literature. So, for example, one of the core topicality debates on this topic is abolish versus reform, and whether or not abolishing the criminal justice system is a method of reforming the criminal justice system. So a precision argument might argue that it's imprecise to say that abolishing a system is the same as reforming the criminal justice system because there's 2 different groups of people who are writing a bunch of literature about criminal justice reform, and both of them agree that there's a very fine distinction, and that's important for some educational reason or important for some semantical reason. The fourth thing I have here is framers' intent. So framers' intent basically means our definition is good because that's how the people who wrote this resolution wanted that word or phrase to be defined. So for the purposes of high school debate, that typically means we're talking about the National Speech and Debate Association or the people who wrote the resolution themselves, which I believe is the NFHS. Framers' intent is a bit tricky in that it's a bit difficult to get a read on these big organizations and what exactly was their intent when they wrote this resolution. But this year, but we can look at previous things when they discussed the actual resolution itself. So, for example, oftentimes NSDA, they'll release a brief when we're voting on what our next year's resolution will be. They'll release a brief or a topic primer, which basically gives a summary of the types of arguments that the affirmative team and the negative team should be able to make. And that gives us a bit of a clue as to what the intent of these organizations were when they gave us this resolution to debate in the first place. The fifth thing here is Brightline. Brightline is not super clear as a standard. Basically, it just says our definition is good for debate because it establishes a clear line as to what is under the resolution and what isn't under the resolution, albeit that's where you get the name Brightline. And then the final thing is predictability, and this is basically the idea that the negative shouldn't have to just shoot in the dark when it comes to preparing arguments. There should be a set number of affirmative plans that they have to prepare for, and they have to at least have arguments ready in place for any plan that falls under the resolution. So the idea that they can predict what types of arguments they may have to go against. So yeah, that's predictability. And then each of these 6 arguments, these 6 standards, impacts fairness in education in some way. Or at least the negative should be arguing that it impacts fairness in education in some way. So when it comes to fairness, for example, the idea of grounds, it really goes hand in hand with fairness. Because if the negative is losing arguments that they should always be able to make, then that's pretty unfair for the negative, because suddenly all of the preparation that they had for, say, their deterrence disadvantage goes out the window, and they can't run those arguments without standing a chance of winning those arguments. Education is the idea that debate should also be educational for everyone in the round. So precision, for example, is a good example of a standard that could tie in with education, because precision talks about how the literature base is specifically saying something, and we should follow the literature base because it's educational and real world. So that would be an example of how we can get to education. So here we have an example of a basic 1NC for a word in this year's resolution, the word enact. I've cut out the card because the card itself was a bit long, but you can see here there's 4 main parts to this basic shell. You have the interpretation, which is the thing at the top, which says the term enact clearly and exclusively conveys legislative action rather than executive, judicial, or administrative. It is distinct from adoption, issuance, enforcement, or prescription. And then the second part would be the violation. So this says the AF does not enact criminal justice reform through legislative action. Fairly simple. The third part would be standards. Here, in this 1NC, the writer has gone with limits and grounds. So for limits, they said multiple actors makes doing research on neg impossible. We have to prepare for every possible topical action that any federal agency or court can make. So that would be the idea that the number of AFs isn't limited, and instead it's way bigger than it should be, because now we can look at any court action or any federal agency's action. And then on ground, this writer says it also takes away core neg ground like politics, disads, and actor counterplans. So these are 2 types of arguments that the negative would believe that they should normally be able to run in any round, but suddenly they can't because the affirmative plan isn't enacting criminal justice reform through legislative action. The final part is just a one-liner which talks about the voters, and it just says vote neg on fairness in education. Okay, so that was a pretty fast rundown of topicality and what the argument basically is. So now let's talk about how we actually debate topicality. So we'll start on the affirmative. So the affirmative on topicality has a couple of main tools at their discretion when it comes to answering topicality. So first, you have we meet their interpretation. So the negative in the 1NC would propose an interpretation of a word, and they would say the affirmative violates this definition, therefore they're not topical. Well, you could technically make the argument that actually we do meet your interpretation of the word. We don't violate the resolution. Here's a reason why we meet their interpretation. The second big thing that the affirmative should always do is make a counter-interpretation argument. Basically, you're saying, no, your definition's bad. Here's an alternative definition that we think is better. So if we're having a debate about the word enact, and the negative comes up here and reads, enact should only refer to legislative action, and the affirmative might come up here and say, counter-interpretation, enact should not only be legislative action, but it should also refer to, say, the actions of federal agencies, because they can enact policies too. So that's a counter-interpretation. This is kind of optional, but at some point the affirmative does need to establish that the plan they're proposing in the debate does meet the counter-interpretation if they are trying to go for the counter-interpretation. And then also the affirmative must accompany their counter-interpretation with reasons to prefer their interpretation. So if you think about the negative 1NC, what we just looked at, the negative usually provides reasons for why they think their interpretation is good. And this is usually the form of standards. So really, when they talk about limits and grounds and fairness in education and how their interpretation is educational for debate or fair for debate, all of that is basically just reasons why they think that you should prefer their interpretation over any other interpretation of a word. So likewise, the affirmative should also provide reasons to prefer their interpretation. So they'd have to answer the negative standards. So basically they'd have to tell us why, say there isn't a violation of limits with the negative interpretation, or why the affirmative plan doesn't actually violate limits. And they'd also have to answer, say, a grounds argument about why politics disads can still be run or actors counterplans can still be run under either the affirmative interpretation or the negative interpretation. And then the fifth thing that the affirmative team should always say is reasonability. We'll talk about this more, but this is a really important argument for the affirmative. And yeah, we'll get to it later. And then the final thing to keep in mind for the affirmative team when debating topicality is it's important to manage your time, because a lot of the times when you're debating topicality, it might get tempting just to like put a bunch of time into it, because sometimes these arguments aren't super well thought out, they aren't super well explained, so it's like, oh, these are easy to answer, so let me just put a bunch of time into it. But that's not always the case, and usually that's a really bad decision, because it's more important to look at not just topicality. It is important to note that if the affirmative loses topicality, they lose the round. So although you have to manage your time, there's a fine balance between dismissing the argument entirely and like putting too much time on it, because you need to put just enough time such that you aren't losing on the argument, but not so much time that you're losing out on other parts of the debate that isn't topicality. So some tips. The 2AC, when they're talking about topicality, they should make enough arguments to make the negative team not want to go for topicality, but they shouldn't waste so much time that suddenly like a disadvantage that the negative team also read only has like 2 responses on it, and suddenly the negative has a really strong disadvantage going into the 2NC and the 1NR. The 1AR should really be going for one argument, and really that means either you're going for a we meet their interpretation argument, or you're pushing your counter interpretation, or you're going for reasonability. Those are kind of the only 3 viable approaches, and the 1AR shouldn't be wasting time trying to go for multiple of those approaches. They should only be going for one, especially considering you're using 5 minutes to answer 13 minutes, and you have likely other stuff that you want to talk about besides just topicality. And then finally, the 2AR should really be making the same time commitment as the 2NR to T. So when we look at the negative debating on topicality, we'll see that oftentimes the negative teams, when they're going for topicality, when they're trying to argue that the affirmative doesn't fall under the resolution and therefore they should win the round, they'll usually spend all 5 minutes trying to talk about that issue. Just because they're only going for one win condition. And if they spend 5 minutes and give a really convincing story about how the affirmative doesn't meet the resolution and how that's bad for debate, that'll guarantee them victory. But that's what good debaters should do. But in this district, and especially a lot in Missouri, that tends not to happen. So for that reason, I'm not saying the 2AR should go 5 minutes on topicality if the 2NR goes 3 minutes on topicality and 2 minutes on the case. You should try and make the same time commitment as the 2NR to topicality, because likely in your guys' rounds, the 2NR probably won't do all 5 minutes to topicality, in which case you still have other arguments besides topicality that you need to answer. So now let's look at negative on topicality. So a lot of the stuff when I explained the structure of topicality and the standards and limits, and when we looked at that, a lot of that is really heavily rooted in how the negative tends to debate topicality. They basically present the idea that the affirmative doesn't fall under the resolution and that their interpretation of the resolution is good for debate. So those are the 2 key arguments that the negative would have to win in order to actually win topicality in the first place. And they basically do that through standards and limits, which we talked about a lot before. So I'll just go over some of the basic, like what a topicality argument would look like as it progresses for negative speech, for the negative team. So the very first speech, the 1NC, they would present the shell of the topicality argument, which is what we looked at before when we looked at T and ACT. Basically, they present an interpretation, a violation, some basic standards, and some basic voters. Then the 2NC or the 1NR, it depends on how you split the block. They'll go into topicality and they'll try and spend a lot of time on, not a lot of time, but a good amount of time on topicality, enough to make the 1IR scared enough to maybe waste a bunch of time on topicality because they think there's potential to lose on topicality. So in order to do this, whoever is answering the 2AC topicality arguments has to answer all of them thoroughly. Because if the 2AC wins one of the three arguments they make, the we meet argument, the counterinterpretation is better argument, or the reasonability argument, then the negative automatically loses on topicality. And basically, that means that if you don't answer all of the 2AC arguments, but you spend half of the 2NC going for topicality, well, then you've just wasted 4 minutes trying to expand on something that the affirmative team can just beat with one line or one argument. And then the other thing that whoever is taking topicality in the negative block should be doing is they want to spend a good amount of time defending and explaining each part of their arguments when it comes to topicality. Especially for lay judges, this is super important because topicality is one of those abstract arguments. If you think about a lay judge, they don't know that much about policy debate itself. So when you walk up there and tell the judge there's a resolution, you have to follow it, the affirmative doesn't follow it, and then you start having a debate about fairness, education, and like semantics, it really doesn't appeal to them, and it tends to be hard for lay judges to understand very flow style topicality debates. So you want to spend a good amount of time explaining the arguments that you're making and really framing the entirety of the round in terms of topicality if you actually think that topicality is a good or the only approach that you have to beating an affirmative team. Finally, as I mentioned before, if you're going for topicality in the 2NR, you're going all in. That means you're going 5 minutes of topicality because you can only go for one approach. If we think about this strategically, if we spend 3 minutes on topicality and 2 minutes on a case turn, that means we're going for 2 separate win conditions, but that doesn't make sense because we only need to win one of those 2 win conditions in order to win the round. It's always strategically more viable to spend more time going for the stronger win condition in the round than it is to split your time and have less developed explanations of the 2 win conditions that you need to actually win the round. And as I mentioned before, in order to win topicality, you need to win first that the interpretation or the definition you provided is better than the affirmative, either because it's better for debate in terms of fairness and education, or because it's just a better definition overall, and that the affirmative team violates your definition. So you need to answer any we meet arguments and basically prove that the affirmative team doesn't fall under your interpretation. So now let's look at how we can actually compare interpretations. One of the most important parts of debating topicality is this whole comparing interpretations debate. As I mentioned before, one of the affirmative team's primary tools for actually answering topicality is to present their own interpretation. So we have 2 different definitions of the same word in this debate, and now we want to look at how can we compare these 2 interpretations such that we walk out of it with a better interpretation. So we can look at the quality of the source. So oftentimes you'll find that there are definitions that people read which are from basic dictionaries. So like Merriam-Webster dictionary or something like that. Sometimes you might find definitions that are from a New York Times article. All of these are credible sources, but when we're looking at the quality of source, they might not be super credible in terms of like precision, for example. So like a legal definition from, say, Cornell might be a better quality source than, say, a dictionary definition of a word from, say, Merriam-Webster. So we can compare the quality of where these interpretations are specifically coming from in the literature. Next, we can look at the legal precision or the context of the word. I've seen a lot of really bad definitions of words where, for example, the word substantial, where they give a percentage, but then when you look at the small text of the actual interpretation itself, it's not talking about what the resolution is talking about. So, for example, if this year's topic is criminal justice reform and we want to read T substantial, it would not be a good idea to read a definition that's in the context of housing and urban development instead of the context of criminal justice reform. So when you're looking at context, you want to look at what specifically is this word being defined for the purposes of. Next is the intent to define. So I mentioned before that sometimes definitions will stem from New York Times articles, and rather than actually provide a concrete definition of what a word means, it just provides a set of examples of what a word means, or even worse, sometimes they just highlight a word and then it'll be like the word, comma, here's an example of the word, and then they move on. So in those cases, we can say the definition is bad because its intent was not to, it didn't have an intent to define. So if we're comparing a dictionary definition with a random sentence pulled out of a New York Times article, well then we could argue that the dictionary definition is better because when the person wrote whatever interpretation you're reading in the round, their intention was to define what the word meant, whereas whichever reporter wrote this random line from a New York Times article wasn't really trying to define a word. They were more trying to just use that word in a sentence to explain maybe some other real world event that occurred. So intent to define. The next thing we can look at is carded warrants. So the best interpretations in my mind are ones that not only provide a definition, but they also provide reasons why that definition is good. So in the context of precision, this is usually where this is most important. So for example, back to the abolition versus reform thing, some definitions of abolition will specifically argue that abolition is distinct from reform because of some number of reasons. Maybe there's historical precedent, maybe they go into the semantics, maybe they go into the actual like interpretations of the words from mainstream media, but whatever it is, a lot of the times cards will include warrants or reasons why the definition itself is good. So we don't need to just pull standards and impacts to explain why a definition is good. We can also look at what has the author of our definition said so themselves about why they think their definition is good. And the final and most important thing when comparing interpretations is standards and impacts. So sure, words from the author themselves about why their definition is good is fine and dandy, but at the end of the day, we still need to put this definition in the context of speech and debate, specifically policy debate, which is what we do when we're using standards and impacts. So we can talk about limits and ground and fairness in education, and we can use those all as justifications for why we think our interpretation is better, because maybe they're more fair for debate, or maybe they're more educational for debate. Etc., etc., etc. And then finally, we'll talk about reasonability and competing interpretations. So reasonability, this is typically what you'll encounter when it comes to reasonability. Most teams will probably say something along the lines of, if the judge thinks that the affirmative team's plan falls reasonably under the resolution, they should err on topicality. So this argument basically says, if the judge takes a look at the plan that the affirmative team wrote, and they think, oh, this is criminal justice reform, or oh, this is immigration policy, or whatever subject matter the resolution that you're that you're debating is actually about, then the judge should just ignore topicality. And the reason why affirmative teams will justify this type of argument is because they would say like, oh, having tiny semantical debates about slight differences in the definitions of a word is bad for debate, because instead of talking about whatever it is NSDA wanted us to talk about, so in this case, criminal justice reform, we're having a debate about words instead of criminal justice reform. So that would be a reason why affirmative teams will read reasonability. Now, it's important to keep in mind that this is not the most precise definition of reasonability, but this is definitely the type of argument for the type of interpretation of reasonability that you'll encounter most frequently. The other thing is competing interpretations. So we just talked about competing interpretations, where basically each side presents a definition of the same word, and then the judge should vote on topicality based on who they think had the best definition/interpretation at the end of the debate. So, yeah, fairly straightforward competing interpretations. So there's a couple of specific arguments when it comes to the theory behind reasonability and competing interpretations. And we'll talk about that when we talk about theory in the future. But ultimately, it comes down to whether or not the negative team believes that dismissing topicality basically for the judge to dismiss topicality based on their own discretion is good, or whether or not that's bad. The affirmative team will obviously say it's good because most of the time judges will vote for the affirmative if they believe reasonability is good. Whereas the negative should try and avoid conceding reasonability because that basically means we're leaving the fate of the debate, or at least the fate of this argument, topicality, up to the judge because we're basically agreeing that the judge should have a say in whether or not the affirmative team is topical, rather than basing everything on the context of the complicated topicality debate that the negative is trying to have in the round. Okay, so lastly, we'll talk about preparing to debate topicality. So first, for affirmative teams, when it comes to debating topicality, if you have a plan already set in place, you have your 1AC written, and you're trying to come up with some blocks for topicality, then it might be helpful to think about what topicality arguments you might face. So the AF that Ari and I am running this year for criminal justice reform is about tax enforcement policies. So what types of T arguments might this AF face? Well, for us, we thought maybe policing, because when we're talking about criminal justice reform in the area of policing, typically we aren't thinking about, tax police or people who enforce tax laws. We're thinking about people on the ground, officers who could carry weapons, who make arrests, and all that normal policing function stuff. So T policing might be one of the common T arguments that we might face. Or we might think about criminal justice reform, and people might say criminal justice reform has to do with prisons, the prison complex, sentencing, etc., etc., etc. Tax law has nothing to do with that. So that would be in another common T argument that for our AF, which is about tax enforcement, that we might think we need to prepare for. So for you guys, when you're thinking about what to prepare for as the affirmative team, think about what T arguments would you read against your own AF, and then think about how that debate would actually play out. So what would be the interpretation that the negative team would read against your AF, and then what would be a good counter interpretation that you think you could win against that AF. And then the other thing you'd want to prepare is answers to standards. So it's typically quite easy to figure out what standards the negative team will read. If you're reading an AF that's through the courts, and you're trying to prepare for T enact should be through legislative action only, it might be fairly predictable to think that the negative team is going to make a grounds argument about actor counterplans, where they say, oh, since you're acting through the courts, you're taking away specific courts counterplans that we might be able to run against AFs that are doing legislative action. So that would be a fairly common standard and predictable standard that you'd think that you would face, and in that case, you should have answers prepared for what you're going to say against that type of argument. For the negative, this is not really about predicting what exactly the debate will look like. It's more about analyzing what types of T arguments you think that you would need, right? So when we're talking about criminal justice reform, there's a host of different T arguments available to us. That's true for almost every topic that policy debate has had. So you need to think about which of these topicality arguments are effective against which types of AFs. So, for example, T enact, which talks about how enacting law should only be done through the legislative branch. That would be a good argument to have against anything that isn't going through the legislative branch. So courts AFs, things that talk about executive agencies, the executive branch, state governments, etc., etc., etc. So we can think about what types of AFs are these T arguments good at, and from that information we can think about what blocks we are going to write for our T arguments, because we have a specific subsection of AFs that we anticipate that we can use our topicality arguments against. So blocks normally look like reasons to prefer your interpretation over the affirmative interpretation. So if we're thinking about a specific topicality argument, say T forensic science, we can probably predict what type of interpretation the affirmative is going to read against our interpretation, and then we can prepare comparative blocks to try and compare the interpretation that we've read to the interpretation that we expect the affirmative team to read. The second thing is, this is more in-round strategy, but you can try and prove in-round abuse. In-round abuse is this idea that some of the arguments you're going to make, like limits or grounds, where you say, we can't run these arguments, or like we don't get to run these arguments because the affirmative team violates topicality. Sometimes the affirmative might make the argument there hasn't been any in-round abuse, and this would occur in a case where, say, you say we can't run Congress counterplans, or we can't run courts counterplans because your AF is through the courts, right? So the affirmative team might say, oh, there's no in-round abuse. They didn't even try to read a court's counterplan, so how do we even know if there's abuse? Now, this is obviously a very extreme example, but a way you could prove in-round abuse in response to that argument is to run that argument that you say, oh, we won't be able to run this argument effectively. And then once the affirmative team immediately shuts down that argument with a single argument, which is very... So, for example, in this case, the court's AF would say, you can't do the AF through the courts because that's the same thing as the plan, right? Then the negative team would have something to jump on when it comes to in-round abuse. And they could say, oh, look at this. The affirmative team made this argument, and they were able to make this argument only because they weren't topical. And then the final thing that you should prepare is answers to reasonability, because pretty much in every debate, when you're debating any good affirmative team, if you read topicality, they will read reasonability, and you should try and come up with reasons why you think reasonability is bad. We'll talk about coming up with theory arguments more in the future, but for topicality purposes specifically, it's mostly about reasonability. So there are some special cases of topicality arguments that we should talk about. So first is mixing burdens. So sometimes interpretations of certain words are based on the ability for the affirmative plan to correct some wrong in the status quo. So, for example, one of the definitions that I've seen this year is substantial. So our resolution talks about enacting substantial criminal justice reform. So some people might come up here, or some debaters might go into a round and they would read a substantial criminal justice reform reduces prison population by this much, right? X%. So this basically mixes burdens because it says your plan is only topical if it can reduce the prison population by this much. If you're reading a mandatory minimums AF and one of your advantages talks about reducing the overpopulation within prisons, well, at that point, you're beginning to mix topicality with solvency, because the negative basically read this substantial argument and says you're only topical if you can solve for this much of mass incarceration. At that point, you're mixing burdens because it sort of blurs the lines between what is topicality and what is solvency. So this is important to keep in mind because there are various theory arguments about whether or not mixing burdens is actually a good thing, and you can engage in a debate about whether or not their interpretation is legitimate, because it's sort of taking two distinct pillars of policy debate, topicality and solvency, and sort of jumbling them together in a way that might not be super effective for the purposes of education or maybe for the purposes of fairness. The next special topicality argument that's worth noting is effects topicality. So sometimes if you read a topicality argument in the 1NC, the 2AC might say, oh, we meet the resolution because one of the effects of the plan is a topical result. So, for example, there are AFs this year that say, we're going to create a new forensic science federal agency. Creating a new forensic science federal agency may not necessarily actually reform forensic science, especially in the area of criminal justice, because it doesn't put in place any new standards, it doesn't regulate any practices, it just says, we're going to establish this agency and things will happen. So the affirmative team might argue, because we create a new forensic science federal agency to oversee forensic science labs, as a result, new standards will be put in place after you pass the plan. And these new standards, which is an effect of the plan, would be a substantial criminal justice reform to forensic science. This is the epitome and crux of effects topicality, because this basically says an effect that happens after you pass the plan is a topical action, rather than the action of the plan itself being topical. Basically, this comes to the idea that the actions that the plan takes, or whatever the affirmative team is advocating for, needs to fall into the resolution. It's not simply enough to say, oh, one of the end results of the plan is that there will be some effect that could be considered a topical action. The reason this is an illegitimate topicality argument is because if you think about it, if effects topicality was legitimate, there'd be a number of different AFs that teams could run, and they'd just make the argument, oh, as long as we prove that we cause new standards to be put in place, or as long as we cause policing practices to change, or whatever else is topical under the resolution, they would say, as long as we cause that, we're topical. And that sort of goes back to the idea of mixing burdens, but it's sort of in a more cheating way because they're trying to avoid arguments and just cheese their way through topicality itself. The final special argument that's worth noting is extra topicality. So sometimes this is most commonly with teams that have plans with multiple moving parts. So one plan that I've seen this year is the United States federal government should disband the enforcement and removal operations of ICE, cease operations of the U.S. Border Patrol, and repeal sections U.S. Code 1324 and 1326. So the affirmative team will make the argument that one or more of their planks are topical. So in this case, the first plank seems pretty topical. ICE is typically regarded as a policing agency, and the enforcement and removal operations branch of ICE is typically seen as a policing agency. So if we read T policing against this plan, the first plank seems to check out, but the other planks aren't going to be as topical. Clearly the second one, which says seize operations of the U.S. Border Patrol, first of all, there's questions about whether or not the United States Border Patrol is police, and second of all, there's also questions as to whether all of the functions that the U.S. Border Patrol does are truly policing functions. So even though the first part of their plan is topical, the second two sections of their plan may not be topical. And what you'll see is the affirmative will say, we're topical because at least part of the plan is topical. And this is the idea of extra topicality. This is illegitimate because even if part of the plan is topical, it's not enough. The entire plan should be topical, and if we think about this from a limits standpoint, if extra topicality was a legitimate argument that the affirmative team could make, well, then we could take any AF that we have on the topic that would be considered topical. For example, on criminal justice reform, we have mandatory minimums, and we could tack on a number of different things, and as long as one part of the plan, the part about mandatory minimums, is topical, whatever we tack on doesn't matter because at least part of it's topical. So we could read a mandatory minimums plan and then include a bunch of planks about climate change, and suddenly, if extra topicality was a legitimate argument, we would have a plan that's mostly about climate change, but also includes a little bit about mandatory minimums, and suddenly that's considered topical, when in reality, and a basic reality check will tell us that no, it's not. So the final thing I'll talk about today is the resolution. So this is specific for this year only, but it's important to learn how to identify keywords in a resolution. So the resolution this year is resolved: the United States federal government should enact substantial criminal justice reform in the United States in one or more of the following areas: forensic science, policing, and sentencing. So when we look at this type of resolution, we need to know how we can identify what words are important. So from a grammatical perspective, we can look at things like the primary verb. In this resolution, we can look at the subject of the resolution, and we can also look at important key nouns or important key phrases that are central to what makes the resolution the resolution. So here's a list of some of the most important words in this resolution. So we have USFG, or the United States federal government. This is the subject. It's the actor in this case. It is doing an action within this sentence. We have enact. This is the primary verb. So the subject is doing something. In this case, the United States federal government is enacting something. Substantial will always be important. It's pretty much in every resolution, at least every resolution I've debated. And it's an important word because substantial it's an important word because it's important to look at what is substantial in the context of different things. So in this case, we'd be looking at substantial in the context of criminal justice reform. Last year, we would have been looking at substantial in the context of arms sales. And in the immigration topic, we would have been looking at what is substantial in the context of immigration. And it all sort of gives us a quantitative outlook on what types of plans are really topical under these resolutions. Obviously, the subject area, criminal justice reform, that's going to be super important because it sort of highlights what type of literature or what type of debate we should be having, or what the debate should at least be about. In the United States, sometimes is important. It's usually not like the most important thing, but in the United States is always at least of some significance because it at least limits the number of affirmative plans, because we can't just have the United States federal government run over to China and enact substantial criminal justice reform there. It has to be inside the United States. And then the final three I've got here are the three areas: forensic science, policing, and sentencing. Obviously, these are keywords to define because they sort of carve out specific areas that the affirmative could run plans for. So that's all I have for topicality today.